Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. The Supreme Court heard arguments in Jennings v. Rodriguez on Tuesday, and here to share the latest is Chung, Chapter Chair of AILA's South Florida chapter. Sui, thanks for joining me. You were at the oral arguments. Can you tell me what this case is about?
This case is about prolonged detention, prolonged immigration detention and removal proceedings, and whether individuals are entitled to bond hearings every 6 months. The first class of individuals in this case are those subject to mandatory detention. The second is those who are considered arriving aliens, and whether either group can pursue bond hearings every 6 months. The last issue is whether the government has the burden of demonstrating with clear and convincing evidence that an individual is not a danger to society or a flight risk, and whether these bond hearings have to occur every 6 months.
What did you hear at the oral arguments?
So there was a lot of discussion on constitutional protections related to arriving aliens. Justice Breyer specifically said it made him pretty nervous to state that arriving aliens did not have those constitutional protections or any constitutional protections, because it seemed that that's what the government was arguing. The government stated that these individuals have no right to be in the United States. The other discussion, big discussion, was why it was that 6 months was identified as the bright line rule. Justice Ginsburg said, why not right away? Why is it that individuals are not permitted bond hearings immediately? Or why is it this 6-month period? How does the Constitution, how do those protections arise at 6 months? The other issue that was discussed at length was regarding delays in adjudications. There's backlogs because there's shortages of immigration judges. The Chief Justice and Justice Alito asked questions regarding whether some of these delays could be attributed to the individual for pursuing relief, pursuing an appeal. So that's a big issue regarding how is it that an individual finds themselves in detention for 6 months or longer. Overall, Justice Kennedy, Justice Gorsuch, not a lot of questioning from them. So it's hard to tell how this case is going to turn out.
Why is this case important?
More and more we're seeing that this administration's priorities are on detaining individuals and facilitating deportations. We're seeing more individuals having to finish their removal cases while in detention, and as a result, we will see more people in this situation of being subject to prolonged detention, particularly if they pursue their cases on appeal and continue fighting for a remedy that they feel that they're entitled to. Another important issue is that their immigration courts are facing tremendous backlogs. There's a shortage of immigration judges. So as the backlog grows, case processing times are increasing longer and longer. So we will see people in detention for 6 months, 12 months, 14 months, and longer. Very important issue regarding this case is the bright line rule of automatic bond hearings. If we do not get a decision that allows for a bright line rule and permits automatic bond hearings, then individuals will be forced to file individual habeases in district court, which will be very cumbersome and difficult because of the processing time for those habeas petitions, and it's really not a remedy to address the situation of those subject to prolonged detention. So if you are in a favorable circuit, such as the Ninth Circuit, where there is a bright line rule, or perhaps even a circuit that has decided the issue of prolonged detention, but on a case-by-case basis, it's important to pursue these cases in the coming months before a final decision is made, and we're encouraging AILA members to go forth and file their habeas cases and make these arguments so that you can get your clients out of prolonged detention.
Thanks, Sui, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.